All right, so today we're diving into contract law, which I know sounds dry, but believe me, this is fascinating stuff. We've got a stack of legal documents here all about contract modifications.
And those tricky what ifs that come up after you've signed on the dotted line?
Right. Like ever felt stuck with a bad deal because you didn't realize you could make changes?
That's exactly what we're going to unpack.
Okay, and I know we need to talk about consideration because I've heard that term thrown around a lot, but honestly, it kind of sounds like legal jargon to me.
It's really not as complicated as it sounds.
So what is it, like in plain English?
Basically, it means there has to be a genuine exchange of value for a contract to be enforceable. Both sides, right? They need skin in the game.
So it's not enough to just like promise something. There has to be something actually tangible on the line for both parties.
You got it. Without that, you're essentially left with a promise, not a legally binding contract. Think about it like agreeing to mow your neighbor's lawn and they promise to bake you cookies in return. That's consideration. Both sides get something specific.
Makes sense. But then what happens if, say, halfway through mowing the lawn, your lawnmower breaks down?
Okay, yeah.
Could you ask for an extra batch of cookies,
Yeah.
like to compensate for the hassle?
Now you're talking contract modification, and this is where things get interesting.
Okay, how so?
See, the rules can actually change depending on whether your agreement falls under common law or what's called the Uniform Commercial Code, often shortened to UCC.
Two different sets of rules. All right, well, break that down for me. What's the difference?
So common law, right, that often governs things like service agreements. It's built on precedent, past court decisions. And under common law, to modify a contract, you generally need fresh consideration.
Fresh consideration. Is that like adding a new clause or something?
It's more like something new of value has to be exchanged. Going back to your lawnmower example, if you just said, hey, this is harder than I thought, I want more cookies, that's not going to cut it. You'd need to offer something additional in exchange for those extra cookies.
Like maybe you offer to weed their flower beds too.
There you go, exactly. That could be considered fresh consideration, right? Because you're providing a service beyond the original agreement. Now, the UCC, that often governs the sale of goods, and it can be a bit more flexible. It recognizes that, business situations are fluid and sometimes modifications are needed, even without the strict exchange of new value.
So it's less about sticking to the letter of the original agreement and more about being adaptable to the situation.
Yeah, precisely. The UCC focuses on good faith between the parties. If both sides agree to a modification and they're acting fairly, it might be enforceable even without fresh consideration.
Got it. So good faith is a big deal in these situations.
Yeah.
But how do you actually determine good faith in like a legal context? Seems kind of subjective.
That's the million-dollar question, and unfortunately, there's no easy answer. It's something courts often wrestle with, considering all the specifics of each case.
So context is everything.
Absolutely. And to really illustrate this, let's look at a classic case, Levine v. Blumenthal.
Okay, hit me with it. What happened there?
So this case was about a tenant who leased a building, right, for a fixed term at a set rent. Then, like sometimes happens, the tenant ran into some financial difficulties.
Oh, no.
Yeah, and they argued that this hardship, that it justified a lower rent payment.
So they were trying to modify their existing lease.
Exactly.
Makes sense. I mean, if you can't afford it.
Right, but in this case, the court actually sided with the landlord. They said that simply experiencing financial hardship, well, it wasn't enough to modify the original lease.
So even though the tenant situation changed, the court basically said, tough luck, you signed a deal.
You got it. And at Levine v. Blumenthal, it really drives home the point that for a modification to be valid under common law, there needs to be a tangible exchange of new value for both sides.
That fresh consideration we were talking about.
Right, like a one-sided modification that only benefits one party without that exchange, it usually won't hold up in court.
That's pretty intense. I mean, it makes sense legally, but man, that could really put someone in a tough spot if they didn't see those changes coming?
It definitely highlights how important it is to think ahead, right? Like, consider potential challenges before you sign, and maybe include provisions that allow for some flexibility, if possible.
So a little foresight in the contract drafting stage can go a long way.
Absolutely. And speaking of unforeseen circumstances, how about we switch gears to a case about a fishing expedition to Alaska?
Okay, now you've got my attention. That sounds like a story. Lay it on me.
So this one involves a crew demanding higher wages, but mid-voyage, and it sparked a legal battle that still gets debated today. It's Alaska Packers Association v. Domenico. Picture this. You got a group of sailors, right? They agree to work on this fishing vessel headed to Alaska.
Okay, I'm picturing it.
They sign a contract, set wage, everything's good. But once they're far out at sea.
Let me guess. They realize they have a little leverage.
Exactly. The crew, they halt work right there and demand higher pay.
Bold move.
And the company, well, they're kind of in a bind, right? Boat full of fish, gotta meet deadlines. They agree to a new contract with a higher wage.
They felt the pressure. But I have a feeling this isn't the end of the story.
You're right. They get back to shore, and the company, they refuse to pay the increased amount. Leads to a whole lawsuit.
No way. So what happened?
The court sided with the company.
What? Seriously?
Yeah.
But they signed a new contract, didn't they?
They did, but the court said it wasn't enforceable because it lacked. What's that key ingredient again?
Let me think. Fresh consideration.
Bingo. The sailors, they were already obligated to do that work, right? Asking for more money for the same tasks, not enough to make that modification legally binding.
Okay, legally, yeah, that makes sense, but I do feel for the sailors. What if the original agreement was unfair? What if they were being exploited?
And that's exactly the debate Alaska Packers still sparks today. It's a really good example of that fine line between upholding agreements and making sure things are actually fair, especially when one side might hold more power in the negotiation.
So what's the takeaway here? Always hash out a good deal up front, especially if you're about to be miles from shore.
That's good life advice in general, I'd say. But for contracts specifically, Alaska Packers really shows us how crucial it is to try to anticipate potential issues and maybe even create some room for adjustments right there in the beginning.
Makes sense. Now, putting myself in the sailor's shoes for a sec, if I was their lawyer, how could I have made their arguments stronger?
Excellent question. Remember how we talked about fresh consideration being vital for modifications under common law? Well, if the sailors had offered something new, along with their request for a raise, say, working longer hours, taking on extra duties, or even suggesting a more efficient process that benefited the company, they might have had a stronger legal argument.
So even in the middle of the ocean, it's about finding that win-win solution.
Exactly. And that brings us to another crucial element of contract law: mutuality.
Mutuality. That sounds very balanced and harmonious. Is that a good thing in the contract world?
It's absolutely essential. It means both sides actually have obligations.
Okay.
It's a two-way street, you see. If only one party is bound, you don't really have a contract.
Got it. So it can't be me promising to bake you cookies every week without you offering anything in return.
Tempting as that sounds, no, it wouldn't be a binding contract. That's what we call an illusory contract. On paper, it might look like a real deal, but without mutual obligation, it's missing a key ingredient.
Okay, so what does an illusory contract look like in, like, a real-world scenario? Any examples come to mind?
As a matter of fact, I've got one. Let's talk about Remsheimer v. Walker.
Remsheimer v. Walker. That name just screams legal drama. What went down there?
All right, imagine this. A whiskey distillery and a distributor walk into a courtroom.
Okay, this is good. I'm already hooked.
Just kidding. They didn't actually walk into a courtroom together, but you get the idea. Anyway, they had a contract, right? The distillery, they agreed to supply a certain amount of whiskey, but the distributor, they had the right to buy as much or as little as they wanted.
Wait a minute. That sounds like a pretty sweet deal for the distributor. They get to call all the shots.
Exactly, and that was the problem. The court said that this agreement, it lacked mutuality because the distributor had no real obligation. They could buy a little, a lot, or none at all.
So the distillery was left high and dry.
Pretty much. The court ruled the contract was illusory and unenforceable. The distributor's lack of commitment, that lack of a real obligation, meant there wasn't a true agreement.
Wow. That's a good reminder that even though contracts can be intimidating, it's so crucial to understand what you're actually agreeing to and make sure it's a two-way street, like you said.
Couldn't have said it better myself. It's also a good reminder that sometimes what's not explicitly stated in a contract can be just as important as what is.
Okay, I feel another twist coming on. What do you mean by not explicitly stated? Are we talking like secret clauses or hidden messages?
Nothing quite that dramatic, but we are entering the territory of implied obligations. Basically, responsibilities that aren't directly written in the contract, but implied by the parties' actions and just the overall context of the agreement.
Ooh, this is juicy. So even if it's not spelled out word for word, a court might still find that a party had a responsibility to do something just based on the situation.
You got it. And we have the perfect case to illustrate this. Wood v. Lucy, Lady Duff Gordon.
Would be Lucy, Lady Duff Gordon. Okay, that name just screams high society legal battle. Tell me everything.
Right. So picture this. You've got Lucy, Lady Duff Gordon, super famous fashion designer, right? She enters into a contract with this Mr. Wood. He's going to be her business partner.
Okay.
The agreement gives Wood exclusive rights to market her designs, and in exchange, he'll share a portion of the profits with her.
Seems a pretty standard business deal so far. What's the catch?
Well, Lady Duff Gordon, she decides to start marketing some of her designs independently.
Oh, no, she didn't. Trying to keep all those glamorous profits for herself.
That's exactly what Wood claimed. He sued, said she breached their contract, but there's a twist.
I'm on the edge of my seat. What's the twist?
The contract didn't explicitly state that Wood was obligated to, actually put in effort to market her designs.
So he could have just sat back, relaxed, and let those fabulous creations gather dust while still getting a cut.
That was Lady Duff Gordon's argument, yeah.
Yeah.
But the court, they saw it differently.
Okay, this is where it gets good. What did they say?
They said Wood's responsibility to actually make reasonable efforts to market her designs, they said it was implied by the agreement itself. It wasn't in black and white, true, but it was clear both parties expected Wood to actively promote those designs. I mean, that's how they'd both make money, right?
So the court recognized a shared understanding, even though it wasn't spelled out in detail. That's wild.
Exactly. Implied obligations are often rooted in those reasonable expectations that naturally flow from, the parties' words, their actions, the whole context of the agreement.
Wow. It's like reading between the lines of a legal document.
Precisely.
That's amazing. Makes you realize that contracts aren't just about the literal words, but the understanding behind them, the expectations at play. Makes you wonder how many business deals hinge on those unspoken agreements.
You've hit on a very critical point. It's not just about what's written in black and white, but the spirit of the agreement, the intentions behind it.
It's a good thing to keep in mind, for sure. Now, we've talked about fresh consideration, good faith, implied obligations. What else does our listener need to know about modifications and what makes a contract truly ironclad?
Well, we've covered a lot of ground, but there's one more crucial concept I think we should touch on. The statute of frauds.
Statute of frauds. Okay, that one sounds kind of intimidating. What's that all about?
It's not as scary as it sounds. Essentially, it's a legal principle that says certain types of contracts have to be in writing to be enforceable.
Wait, really? Not all contracts have to be written down. I thought that was a hard and fast rule.
It's a common misconception. Lots of agreements can be made orally, and they're still legally binding. But the statute of frauds, it says some types of contracts are so important, so prone to misunderstandings and disputes that they need to be in writing to, avoid problems down the line.
Okay, yeah, that makes sense. So what kind of contracts are we talking about here? Give me some examples.
The specifics vary a bit depending on the state, but generally it includes things like contracts for buying or selling land, real estate, or agreements that can't be performed within 1 year, contracts to pay off someone else's debt, and agreements made in consideration of marriage.
So if you're making a deal for real estate or something that's going to take longer than a year, best to get it in writing.
Exactly. Protects both parties. Provides clear evidence of what you agreed to, which is really important if a dispute pops up later.
And I imagine having those terms in writing would be super helpful when considering modifications, right? Gives everyone a clear starting point.
Exactly. And, when it comes to modifications, the statute of frauds, it actually raises an interesting point. See, even if the original contract was required to be in writing, some modifications might not need to be. Depends on what the modification is, what state you're in, all that.
Oh, wow. So you could have a written contract with a legally valid verbal modification.
It's possible, but you got to be careful. While a verbal modification might be enforceable under certain very specific circumstances, it's also asking for complications, maybe even disputes. If you're ever unsure, best to talk to an attorney.
Great advice. Now, this has been incredibly helpful already. We've covered so much from the nuances of consideration and good faith to these implied obligations and the statute of frauds. What else should our listener keep in mind when navigating contract law, especially because things move so fast in the business world these days?
That's a really good point. And, with so much business happening online now, it's even more important to really understand the basics of contract law. And look, I know we've gone over a lot of complex stuff today, but it all comes down to a few key takeaways.
All right, lay 'em on me. What are the essential things our listeners should remember as they go forth into the world of contracts?
First and foremost, a contract is a legally binding agreement. Read and understand everything before you sign. Don't be afraid to ask questions, get clarification if anything seems ambiguous, and if you need to, talk to a lawyer.
Do your due diligence. Don't just skim and sign.
Exactly. And second, circumstances change. While you can't predict everything, try to think about potential challenges before they arise. See if you can build in some flexibility where it makes sense.
That foresight we talked about earlier.
Yes. And finally, always act in good faith. Be honest, be transparent, be fair in your dealings. A contract, it's built on trust. Approaching it with integrity is like the best way to make sure things go smoothly and everyone gets a fair deal.
Couldn't agree more. Integrity and clear communication are key. Now, before we wrap up this deep dive into contract law, anything else you want to add? Any final pearls of wisdom for our listeners?
We've talked about a lot of the nitty-gritty legal stuff, but at the end of the day, having a good relationship with the people you're making agreements with, that can be just as important as the contract itself.
Oh, interesting. So it's not just about the legal framework, but the human element too.
100%. Contracts, they're really about collaboration, right? Achieving shared goals. When both sides respect each other, communicate openly, actually want to find solutions that work for everyone, well, those inevitable bumps in the road, those moments when a modification might be needed, they become a lot easier to handle.
Makes sense. Way easier to work through challenges when you've got that foundation of trust and understanding.
Exactly. Now, you were talking about how fast business moves these days. Can't forget how much technology has impacted contract law, too.
Oh, for sure. So much business happens online now. How has that changed things from a legal standpoint?
Well, for one, electronic signatures, right? They're totally mainstream now, totally legally binding in most cases. That's definitely sped things up. And then you've got the whole world of e-commerce, which has led to a whole bunch of new laws and regulations specifically for online transactions.
Makes sense. Feels like the law is always trying to catch up with technology.
You could say that, but it's also kind of exciting, right? Means contract law is always evolving, always adapting to how we do business and interact as a society.
True. It's not just some dusty old topic. It's very much alive and kicking, constantly changing.
Exactly. I mean, think about it. Every time you click I agree on a website, you're engaging with contract law, whether you realize it or not.
Whoa, yeah. That's a bit of a mind-blowing thought. Guess I'll be reading those terms and conditions a bit more carefully from now on.
Always a good idea. At least give them a quick once-over, even though I know they can be super long and jargony.
Okay, so to wrap things up for our listener today, what are the key takeaways from our deep dive into contract modifications?
Number one, remember that a contract is a legally binding agreement built on that idea of mutual exchange, right? Modifications, those what-ifs we run into, they can get tricky. Under common law, you generally need fresh consideration, a new exchange of value for it to hold up. But under the UCC, things are a little more flexible. Good faith plays a bigger role.
We also dove into some fascinating cases. Levine v. Blumenthal, remember that one? Really highlighted the whole fresh consideration thing. And then there was Alaska Packers, which showed us that a pre-existing duty, that's not enough to count as new value.
Oh, and let's not forget Wood v. Lucy, Lady Duff Gordon. Sometimes obligations are implied based on what's reasonable to expect, the spirit of the agreement. And of course, getting those essential terms in writing, can't stress that enough, especially for agreements that fall under the statute of frauds.
It's been amazing to see how these legal concepts, which can seem really dry on paper, actually play out in real-world situations. Lots of cautionary tales, for sure, but also a really practical roadmap for navigating the world of contracts.
It's been a pleasure joining you on this deep dive. I always love digging into these cases. There's always something new to learn.
Absolutely. And a huge thank you to our listener for giving us such great material to work with. For everyone listening, remember, a good grasp of contract law is power, whether you're talking business deals or personal agreements. So keep those legal brains engaged, and we'll catch you on our next deep dive.
We've covered so much ground today, from fresh consideration to good faith to implied obligations. But honestly, if there's one big takeaway I hope you walk away with, it's this. A well-written contract is great, essential even, but a strong relationship with the people you're making that agreement with, that's priceless.
That's an interesting way to put it. So it's not just about the legal stuff, but the human side of things, too.
Exactly. At the end of the day, contracts are about working together, right? Trying to achieve something together. When both sides come to the table respectfully, communicate openly, genuinely want to find solutions that work for everyone, well, it makes those inevitable bumps in the road so much easier to deal with.
Makes sense. Like, it's got to be way easier to handle those moments when a modification might be needed if you've already got that foundation of trust and mutual respect.
100%. And speaking of navigating challenges, remember you mentioned earlier how fast the business world moves these days? Technology, man, it's really changed the game for contract law too, you know?
Oh, absolutely. I
Okay.
mean, think about how much business happens online now. It's
Yeah.
huge. What kind of impact has that had from a legal perspective?
Well, electronic signatures, for one, they're everywhere now, and in most cases, they're just as legally valid as a pen and paper signature, which has definitely made things faster. And then there's e-commerce, right? That whole world has basically created a need for a whole new set of laws and regulations.
Wow. Yeah. It seems like the law is always playing catch up with technology.
It's true, but it also means contract law is a very dynamic field, always changing, always adapting to new situations and how we do business.
That's a good point. Makes you realize it's not just about these like old, stuffy legal documents. It's very relevant to how we live and work today, online and offline.
Exactly. Think about it. Every time you're on a website clicking I agree to those terms and conditions, you're interacting with contract law.
Whoa, yeah. You're right. That's kind of a mind-blowing realization. I guess I should start reading those a little more closely, huh?
It's never a bad idea, even though I know they can be long and confusing sometimes.
Okay, so to sum it all up for our listener today, what are the most important things to keep in mind when it comes to contract modifications?
First and foremost, remember a contract is a legally binding agreement, and it's all about that idea of mutual exchange. Modifications, those what if scenarios we talked about, they can get complicated. Under common law, you generally need fresh consideration, meaning a new exchange of value, for the modification to be enforceable. But under the UCC, there's a bit more flexibility. Good faith becomes a bigger factor.
Right, and we talked about some really interesting cases along the way. Levine v. Blumenthal, that one really highlighted the importance of that fresh consideration. And Alaska Packers showed us that a pre-existing duty doesn't count as something new.
Oh, and who could forget Wood v. Lucy, Lady Duff Gordon, talk about a case, really showed how obligations can sometimes be implied, based on the circumstances, what's reasonable to expect. And of course, getting those key terms down in writing, especially for those agreements that fall under the statute of frauds.
This deep dive has been amazing. I feel like we've really gone from the high-level theory to those nitty-gritty details. So many cautionary tales, but also lots of practical advice for anyone who deals with contracts.
I'm so glad we could do this deep dive. These cases are always fascinating to talk about. There's so much to unpack.
Absolutely. And a huge thank you to our listener for providing such interesting material. Remember, everyone, understanding contract law is empowering, whether you're talking about business, your personal life, really anything. So keep those legal brains engaged, and we'll see you on our next deep dive.